also have 30 days to appeal that decision. So I just wanted to set up a little bit of information about that. In regards to a contact, we actually have set up a point of contact within my organization who is handling all calls. Yeah, I need to bring her donuts this week. She is taking all of these calls and reviewing them on a case-by-case individual basis and then escalating them as appropriate up through my bureau chief and then to me if needed to review and to make sure that we're individually managing each of these based on the documentation and records that we have available.
Okay, the legislature is going to need to be kept updated on how this is going. So someone calls, first off, the 30 days that they have to appeal, they appeal to you at DAS, not the individual agency that they try to get a decision with. All appeals are going to you and your department, correct?
The appeal process actually is managed through the Employment Appeal Board through DIA. So all of the appeals are managed through an ALJ, so an administrative law judge within the Department of Inspections and Appeals would hear each of these appeals. There's also an informal, so that's kind of the formal appeal process. And again, referring back to that first handout that I provided you, that cites the rule at the top, 5426. At the bottom, you will see the two rules related specifically to the appeal processes for this rule. So there's both an informal and formal appeal process. And all of those are handled, as I said, through the administrative law judge within DIA.
So what is your department's role now? Now I'm confused.
So we would represent, so there's a formal hearing that would take place where if the employee chose to appeal, and the employee would then come and provide their reasons, the reasons for the appeal, and we would provide, we would talk about the documentation or whatever we had that justified the exclusion, and then a decision would be made. And I do have a stack of decisions from recent years here in which that show, I meant to count them this morning, I apologize, I didn't do that, but a stack that at least show affirmative decisions related to decisions we've made on exclusion and those appeals that have gone to the Employment Appeal Board in recent years.
So in the meantime, 30 days for them to know, how long do these take? Because if someone's trying to get a job with state government, are you essentially shutting the door on their opportunity to apply if they've got to go through an appeals process and the job process continues on without their name in the mix while they're appealing? Is that how?
The job process does continue on, and it does depend. Some hiring processes are shorter than others. I can tell you with experience, for the ones that I've personally done as a hiring leader, generally speaking, they take longer than 30 days. But it does depend.
So basically, they are shut out of trying to apply for a job, even if they're incorrectly put on this list. Because most employers aren't going to sit around and wait and find out, oh, I guess she is qualified to apply.
Sorry, I wasn't trying to interrupt. Certainly there's the 30-day window, but there's also, again, the informal appeal process. You will see that that's 61.3, in which, that could be an expedited process in which a more informal to the director, an informal request. So that could be expedited and could go faster, certainly. And we've had these requests for reconsideration come to us, and we review documentation, but often, frankly, they do come to us and we review the termination and the termination record that we've received, and many of them do continue to stay in excluded status, but we certainly do review every one that comes to us for reconsideration.
Give us some examples of other reasons people might be on the do not hire list for other state agencies. I have the understanding that each state department and state agency also can put people on that or designate them as do not hire. I don't know your official lingo, but you know what I'm trying to say.
So this is DAS's rule that DAS is responsible for administering, but it applies to all of executive branch.
Okay, but it's my understanding that there's other agencies out there that are adding to your do not hire list. Have they been notified that they're not allowed to do that?
Sorry, I apologize if I'm not explaining myself, but this does apply to all agencies. So this rule applies to all agencies. We're responsible for administering it, and we have the mechanism for administering it, especially for those merit-covered positions. As I said earlier in my testimony, all those merit-covered positions, all of these applications have to come through us. So we're responsible for managing that. So essentially what happens at a high level again is that at the time that an employee is terminated, again kind of focusing here on letter G within the rule, there would be a termination kind of code of sorts that would come through that would indicate to my team that that termination was an involuntary termination, so a discharge. And we would then look to ensure that there was appropriate documentation to support that involuntary termination. So we would look generally, almost always, for a letter from the department that would outline, it's generally the letter that's to the employee that talks about the term of their separation. And if we were to receive a code from one of the agencies for that involuntary termination, we didn't have that documentation, we would go back out and request the documentation. So we will make sure that we do make sure that all of these involuntary terminations are truly supported in our involuntary terminations before doing that code.
So are you saying that you have documentation for every item that's on the do not hire list? They're coded, your office is responsible for knowing, yes indeed, they do qualify to have this designation to be on this list, or you're saying you don't have the documentation?
I'm telling you that that is our current process. So yes, except for the fact that this rule does go back to 1987.
So your answer would be, no, you don't have the documentation going back prior to maybe when you began?
No, we do. It's hard. Can I say that we have every single one dating back to 1987? I probably can't sit up here and say that. I mean, to be honest, right? But we have fairly strong records, and certainly as of recent years, even prior to my administration, or to my time in this role, we've been fairly firm about that documentation. But could there be a termination from 1989? And if someone called and asked us, and we didn't have the documentation to support, we would clearly review that and make the determination that was appropriate. But we're fairly diligent. We understand that these are people's livelihoods, and that we wouldn't just lackadaisically, without the proper documentation, make these decisions. But it's a big system, and it dates back to 1987. So.
Okay, and I'm not sure if I have my number correct. I'm kind of a ring man with numbers. I think I do. 76 people from the Iowa Veterans Home have been put on the do not hire list since 2011.
I don't know that off the top of my
That
head.
was a major red flag to me, especially with all of the issues that we had going on at the Veterans Home. Would you give us a report back to our committee on the rationale for putting that many people on the Veterans Home on the list? And I also like verification from these other state agencies that they are also taking the do not hire list and adding their own members for their own hiring process. Once you get their list to them, do they run it through another list of their agency?
Not to my knowledge. To my knowledge, again, this process is administered by us.
Right.
All the departments participate in the process, but is there something else happening? And I certainly can't comment on that. Not that I'm aware of.
And I want you to find out for us. I mean, I think that you can send out notifications to people that handle the hiring and firing to find out that it's going on further out in your department. Could you walk us through human resources, procedures for at-will employees? What is human resources role in hiring at-will employees?
So going back to the merit system and if you look at 8A 411, which outlines the merit system and talks about all of the components that make up the merit system, including hiring and then the just cause for termination. Those are that process, and that oversight kind of is specific to merit covered employees. So those processes and our involvement, a centralized human resources involvement in at-will hires isn't required. So those at-will hires, truly at-will, or frankly non-merit, not even at-will, non-merit hires do not have to flow through that kind of centralized process that I discussed earlier, in which those requisitions flow through our applicant tracking system. They can, and some choose to, but they're not required by code or rule.
Okay, and we've had concerns about many people, especially in DAS, being hired without the positions being advertised, and then the pay is substantially more than the person that they replaced. You had mentioned earlier on that you helped with the job classification and determining the pay. Could you walk us through how you put together the job classification and the pay? In particular, and this is probably before your time, but we had the 3 who replaced the department. There were 7 that left and 3 who replaced them. They were all hired as bureau chiefs without a bureau chief. How did that happen?
Yes, so I'll walk through the high level process first. So yes, we have about 800 classifications. What happens is each person has what's called a PDQ, a position description questionnaire, that's filled out. Those are reviewed very continually, but certainly at the time that a new position is created or a position is replaced, and those would all come into the human resources enterprise. And those PDQs then would be reviewed by my team to then match up that individual person's job. So that position description questionnaire is supposed to outline the detailed responsibilities and duties assigned to that individual person. My team is then responsible for taking that individual PDQ, reviewing it, making sense of it. So there's generally a lot of going back and forth with the hiring authority to make sure that they understand the intricacies of that particular job, and then matching it up to one of those 800 classifications. At the time that each of those 800 classifications have a pay grade associated with them. So again, a minimum and a maximum. So a minimum pay and a maximum pay associated with that classification. Is that the kind of high level? Does that help answer at least the high level?
Right. So would it be unusual for a person to come in with no experience to replace someone who worked in state government for years, basically doing the same job, but come in day one at the very max of a pay scale?
So we're talking in generalities, so I'll do my best to answer in generalities. It could perhaps, when a job changes over, especially in the situation of a reorganization, the PDQ could look different. So perhaps the duties or responsibilities look different, and therefore perhaps then the classification resulting would look different. A couple of things. So there's a range for each classification, a minimum and a maximum, and nobody can be paid. Generally can't be paid outside of the maximum of that range. What happens at the time, and generally speaking, for merit covered and contract covered positions, we start individuals at the minimum of the range. However, with justification, generally by a resume, we can do what's called an advanced appointment rate, and therefore bring them up higher in the range if justified by kind of 2 things. A, is it required based on kind of the pool, the candidate pool? So you were having a hard time finding the talent that you needed, having a hard time recruiting for that position, and then B, the justification of both experience and education to justify being paid higher in that salary range.
So if you didn't advertise, hence no pool, then that would increase your chances of getting a higher salary for your friend that you want to work for state government.
One thing that I did not know, I think I specified that process is specific to contract and non-contract. There are more liberties for a true at-will position to be able to, we still ask for justification, of the placement within the range, but there is more flexibility to bring, again, within that range associated with the classification to determine salary.
And who makes those decisions for the at-will position salaries? We're still trying to figure out who has the authority and who can decide the pay scale.
Well, the pay scales are set, so those are associated with, again, those 800 classifications. So those are set by human resources. Those are defined. Who determines the individual pay is the hiring authority. For an at-will position, again, though, we would ask for justification of that salary if it is indeed above the minimum. But the hiring authority does have the ability to determine pay within the range.
So if we wanted to see who the hiring authority was for each person, would we find that on their PDQ, or where would we find? So would it be the person listed on the PDQ has the ultimate authority in setting the salary?
So the person on the PDQ would be the individual's supervisor.
Okay.
So depending on the structure of an agency or a department, so if we're talking line level, that supervisor may not ultimately, depending on the organization, may not have the ultimate authority, but that would be the person who at least administered the decision. But I can't speak on behalf of how it works, for every hiring authority probably does it a little differently.
Okay, so does your department decide the pay for any of the at-will people at EAS?
The ranges are set, so yes, we determine the range. The ranges are set for everybody. The hiring supervisor within, so I think you're asking specifically about DAS, just want to make sure, right? Specifically within DAS, the hiring leader. So if I had a posting for an at-will position within human resources, either I would do that or one of my bureau chiefs, I would give the discretion to my bureau chief to set the salary within that range. But I would ask for justification. Had one not too long ago where I wanted to make sure that but every hiring supervisor will do it a little bit differently, but they would have the ability to set that pay within the range with justification.
Did you ever feel pressure from Director Carroll to set the pay range at a higher scale than what the job actually required?
Pay range, no. Pay ranges are set. Those are determined,
and
we're not changing the pay
put
range.
that person in that category for that pay range, that job position in the category. Am I not, like a bureau chief or someone who does not have a bureau?
I wasn't here for those, so I
Okay.
can't comment on those positions.
Okay, so who was the person that helped with those?
I think there were a number of people involved, but in my chair at the time was Jeff Pankman.
Jeff was responsible for making.
Jeff was I don't know that he was ultimately responsible, but he certainly was in the chief operating officer position at the time in human resources at the time that those decisions, that activity occurred.
Okay. Could you walk us through what happens when an employee in another state agency is experiencing sexual harassment or violence in the workplace? Do they then report that to your department?
Often, yes. Those do end up coming to us. They don't always. Often they can also be reviewed. Kind of, it depends on the scope, but oftentimes we're involved or at least aware of them. Depending on the level of them, we actually get involved in actually conduct an investigation. So I guess the answer is it kind of depends, but generally we're usually always, we're pretty much always aware.
Okay, so maybe for the sake of the committee, because I know we're going to have issues related to violence in the workplace and persons who work in state government who have gone through this process, walk us through what an employee at a different agency would do, say the Iowa Law Enforcement Academy. We've seen that happen where someone was reported, or Iowa Veterans Home. Walk us through what an employee would do if something was going wrong and how they would communicate with your department and how and when.
Yeah, again, it depends on the process, it depends on how it's happening in the agency. Generally, it would make sense to go to your supervisor if the supervisor